Welcome to Environmental Law course, dear learner and viewer. Today we are going to deliver the lecture on common law remedies for environment protection under law of public nuisance in independent India in reference to the judicial recognition of the law of public nuisance and how the law of public nuisance, which has been envisaged under the Indian Penal Code under section 268, 290 and 291, including 188 of the Indian Penal Code and its procedural version under Section 133 CRPC have been made effective through judicial pronouncement in India. In this reference, we will be discussing the leading case on the point and to see that how this law is going to be relevant in the independent India in matters of all kinds of environmental pollution, and we will see that the potentiality of this law is still relevant in the independent India. To this end, what we will going to discuss is the fact that we will be discussing directly that we are in a comfortable position to appreciate the entire problem of environment public nuisance law, which has been underpinned under the Indian Penal Code under section 268, 290, 291 and section 188. Now we are moving to see that how this law has been taken and reacted by the judicial pronouncement, and the judicial pronouncement in that respect we will be discussing the most landmark case on the point, which happens with the Municipal Council Ratlam versus Verdichan, which has been handed down by the Supreme Court in 1980, although there happens to be many cases on the point which deals with Govind Singh versus Shanti Swarup, PC Cherian versus State of Kerala, Ajit Mehta versus State of Rajasthan, K. Ramachandra Mayu versus District Magistrate, and there are series of cases wherein the law of public nuisance section 268 of the Indian Penal Code vis-a-vis the section 133 CRPC has been applied by the court to remove the public nuisance, and then we try to see that how this law to a great extent have combated and prevented the water, air pollution, sanitary condition, cleanliness and hygiene in India. And then we will be looking at the question that how this law is going to impact on the very aspect of the Indian Penal Code. And then we see that in the Municipal Council in Ratlam, let's see the fact of this case, which is important. Though it has bearing on section 268, 290 and section 133 CRPC, but the fact of the case is something very interesting. The fact is that the court has an occasion to dwell on the ambit and scope of section 268 and 133 CRPC. There is a kind of a colony which was very posh and where the people are living. And along that colony where the people are living, that the approach of that colony, it so happened that has been waterlogged, and then the resident of that colony have complained to the Municipal Council Ratlam to remove the waterlogging. The waterlogging has assumed a menacing proportion in the sense that the scorpio, the snakes, the obnoxious fumes and odor, and it was very difficult for the person living in that area to exercise their public right and dwelling on that property to have a clear kind of an access. So the insanitary condition which has been created by the municipal by the waterlogging in realization of their property right and the public right, the residents have complained to the Municipal Council Ratlam to clean that garbage, filth and malodorous an obnoxious kind of a fume which hovered around the locality. Then after having a formal complaint to the Municipal Council Ratlam, then the people complained and invoked section 268 of IPC, and it also tried to see that how section 133 CRPC, where the magistracy has been empowered to remove the public nuisance of all kind, because if we peruse section 133 CRPC, then we find that there is a long list of conditional removal, and then the conditional removal pertains to a large number of items where the magistrate is competent enough to order for the conditional removal. It's a different thing that the magistrate can only order for the removal on the police report or any kind of a public report or any kind of a complaint, or it can remove of its own motion or when it deems fit. But here the complainant has been regularly complaining about the removal of the public nuisance to the magistracy as well as the municipal council Ratlam. The case saw that from district court to High Court and to Supreme Court, the case has been a kind of entire litigational cycle of this case happens to be very interesting for such a basic need of the resident of uh, in the jurisdictions of municipal council Ratlam, and the people who were suffering and complaining about the water logging and insanitary conditions have been put into a kind of a miserable conditions, and even then the municipal council was not in a position to remove the public nuisance. The municipal council was not in a position to remove the public nuisance, and then the case went to district court, then it went to the High Court and went to Supreme Court. When it reached to Supreme Court, what is interesting to be noted about this case, that this case went to Supreme Court under a special leave petition. And as a student of law, we know that a special leave petition is invoked when then there is a serious miscarriage of justice, and then if the court is not going to hear the case by way of a special leave, then it will be travesty of justice, it will be miscarriage of justice, and then court is bound to hear. And in this case, we find that this case was filed in Supreme Court in SLP right from district court and high court when the remedy was not granted to the resident. Then the resident approached to the Supreme Court under the by seeking its special leave petition jurisdiction, and the court has rightly entertained. The court in this case is speaking through Justice V.R. Krishna Iyer as well as Justice O. Chinnappa Reddy have delivered the judgment, and this judgment is said to be a landmark judgment on the issue of on the interpretation of the section 268 and 133 CRPC. And this case, what happens that the Supreme Court first tried to emphasize on the point that we are going to hear a kind of a dispute which is a kind of a altercation, a local altercation, that this is not a dispute but merely an altercation between two persons or an street altercation. The court very sarcastically remarked about this case that it is going to be an street altercation, and how the Supreme Court is now giving its thought to this street altercation. Why? Because section 123 of Madhya Pradesh Municipal Council Act tries to enumerate the functions of the municipal council. The court have a very detailed perusal of section 123 of Madhya Pradesh Municipal Corporation Act, and it has noted that what are the basic functions of the municipal corporation. Having perused that what are the basic functions of the municipal corporation, the court reached to the conclusion that municipal council has a mandatory duty to remove public nuisance. Whereas the municipal council, right from the entire litigational strategy which was in district court and high court and the Supreme Court, have taken the bogey of financial crunch. And it is because of the financial crunch, the municipal council, Ratlam, is not in a position to remove waterlogging and insanitary condition and redressing the complaint of the people. So much so the court also realized the very fact that the municipal council, instead of claiming for the financial inability and the financial crisis, it happens to go to district court, go to high court, and then defend itself in the Supreme Court. And what was the defense from district court to high court to Supreme Court is nothing that we don't have money and enough money to remove the public nuisance under section 268, and spending a lot of money for its defense in various courts from district to high court and high court to Supreme Court. But it doesn't have any kind of a money to remove the public nuisance, as it has been complained by the resident of the jurisdiction of the municipal council. And then the Supreme Court tried to see that what is the law relating to public nuisance, what is the duty of the municipal corporation. Then we can see that in this respect, what has been laid down in the municipal council is the fact that there are three kind of a duty. The duty number one of municipal council Ratlam, number two the duty of the magistrate under section 133 CRPC. So the duty of the municipal council Ratlam is as enumerated under section 123 of the Madhya Pradesh Municipal Council Act, that has been seriously perused by the court, and the duty by the magistrate, it has already been envisaged under section 133 CRPC, that is also there. So there are two kinds of duty and two sets of duty, or two actors which were involved in this case. Was one the municipal council, another was the magistracy. And then Supreme Court heard the plea of the municipal corporation in matters of the financial crunch, and then the Supreme Court was of the preliminary view that it is an street altercation, it's not a fit case which should and which ought to have come to Supreme Court, till Supreme Court, for having such a small and a paltry and a trivial issue of clearance and removal of the public nuisance. Having taken the entire factor into consideration, the court was of the view that the court which decided the case in 1980, as it has been mentioned here, the AIR 1980 Supreme Court 622, then what we see, the court in this case have not applied, and what it has not applied in the Ratlam case is the fact it has not mentioned Article 48A, it has not mentioned Article 51AG, which was there in 1976 as a constitutional amendment, and this case which came in 1980. Rather, Justice V.R. Krishna Iyer and O. Chinnappa Reddy in this case has applied Article 1, Article 47, which talks about the health. And this is very important in this case, that instead of relying on the constitutional amendment to the environment and casting a duty, and when it talks about the duty, it focuses on municipal council and the magistrate. It's not coming on the duties of the state which has been prescribed under Article 48A, that the state shall endeavor to protect and improve the environment, including the forest and wildlife of the country. Rather, the judgment have relied on Article 47, which talks about the health and the sanitary conditions. And then this is a very unique kind of an argument which has been built in this case, and the case in point is very important, that how it tries to see three laws which are very important. Those three laws happens to be that the three laws in this case happens to be that the one is Article 47 of Indian Constitution 1950, and then Section 268 to 90 and Section 133 CRPC. So it's a different kind of a domain, and the different kind of a jurisprudence has been laid down in this case that has to be studied in a very careful manner, and that careful manner is that what this case try to convey, the basic point it happens to be in this case in relation to the judicial recognition of the law of the public nuisance law is very important. The judicial recognition is that it directly hit hard to Section 268 to 90, 133 CRPC and Article 47 of the Indian Constitution. And then it tries to let down the ratio and arbiter, and the ratio and arbiter of this case says that one thing which is very important, that Justice Krishna Iyer has given a very broad and a sweeping meaning to Section 268 and 133 CRPC to include environmental protection for the first time in this country by a law which is called the Indian Penal Code of 1860. What it held that the magistrate has a mandatory duty, and the court has laid down that the language of Section 133 CRPC appears to be discretionary. But if you realize when there is an existence of the public nuisance, then this law assumes a mandatory duty to act when public nuisance is there as a glaring example and very evident. Then the language which appears to be in Section 133 discretionary assumes the role of a mandate by the magistrate to remove the public nuisance. And here it also tried to see that a very important aspect has been added to 268 and 290 is the Section 188 IPC, which supports penalizing disobedience of lawful order causing harm to health and safety. That was also invoked. So in that respect, we see that the addition of the section Article 47 of the Indian Constitution and as well as Article Section 188 CPC that penalizes the disobedience of the lawful orders are causing harm, health and safety. Therefore, the judgment says that the decency and dignity are the non-negotiable facets of the human right, and decency and dignity. While the argument of the decency and dignity as a non-negotiable facets of human right was taken in this case, but no reference to Article 21 and Article 48A was there in this judgment because it tries to see its ratio beyond Article 21 and 48, and rather it tried to see its judgment in matters of what we can say that it more relied on Article 47 of the Indian Constitution, which talks about the sanitary conditions and the healthy conditions, which is very important. So, it is a very novel approach which has been adopted in Municipal Council Ratlam's case in matters of giving effect to human right to cleanliness and decency and dignity, and that decency and dignity which it talks about as a matter of a health and right, it means that the Municipal Council Ratlam has given effect to decency and dignity, and that way we can say that this case is the first case in India to recognize right to sanitation as a human right and a fundamental right, and therefore the right to sanitation, which were hitherto removed remained not so much vocal and articulated that this case has opened has made a very a beginning of recognition of right to sanitation, right to decency, right to dignity as a matter of the human right under the pale and authority or the provisions of Article 47 of the Indian Constitution. Having said so, that it touched upon on a very seminal issue of the people's enjoyment of right to life, dignity, decency, sanitation as a part of right to life and as a part of the realization of Article 47 of the Indian Constitution. The Supreme Court, speaking through Justice V.R. Krishna Iyer and O. Chinnappa Reddy, has laid down a very unique jurisprudence in matters of the removal of public nuisance and law of public nuisance in 1980. And it is also very surprising to see that this case was decided in 1980, but per curiam we see that it does not mention any kind of the provisions which has been engrafted by the 42nd Constitutional Amendment, Article 48A and Article 51AG. It does not mention about it, though without mentioning the potentiality of the judgment goes beyond Article 21, 48A and 51AG, that even in 1980 that right to sanitation has been laid down by this case. And the importance and the relevance of this case of Municipal Council Ratlam versus Vardichan lies in the fact that it came very heavily on the Municipal Council Ratlam, saying that the financial crunch is not an alibi, is not a kind of a defense when the Municipal Council under Section 123 of the UP Madhya Pradesh Municipal Council Act is empowered to exist and to justify its statutory existence, then justification of statutory existence requires that the municipal council has to clean the garbage, has to clean the dirt, has to remove the filth, and then the kind of a complaint about the public nuisance which has been raised by the public, whether you are financially capable or incapable, it is immaterial. Just to justify your existence and statutory existence as a municipal council, you have to simply clean. So these words are so terse and strong enough to cast liability on the municipal council Ratlam beyond what we can say what is discretionary and what is mandatory. And then while delineating on the aspect of the duty of the Municipal Council Ratlam, the Supreme Court came very heavily on the aspect of Section 133 CRPC, and it has made very clear and in a very unmistakable term, the Supreme Court laid down that the language of the Section 133 CRPC is appearing discretionary, but when there are circumstances of the existence of the public nuisance, then this language assumes automatically the tone and the tenor of a mandatory duty, and then it upheld the magistracy's power and authority, which is in relation to the removal of public nuisance under Section 268 of the Indian Penal Code, and giving a very teleological interpretation of Section 133 CRPC. The Supreme Court, speaking through Justice V.R. Krishna Iyer and O. Chinnappa Reddy, it says that when public health and safety remains at stake, then it is no more a discretion, it acquires a mandatory import, and in the language of the court, which has been quoted here, that the guns of Section 133 CRPC go into action wherever there is a public nuisance, or and this is something very unique which has been laid down by these two learned judges, honorable judges in the Municipal Council Ratlam case, that all power is a trust. So the magistracy who enjoys the power, it is a kind of a power which have more of a kind of a trust. It's a kind of a public duty, and it's a kind of a trust which the people has bequeathed to the authorities like district magistrate, subdivisional magistrate, or any magistrate at the district headquarters. So the power which has been enshrined under Section 133 CRPC should be taken not only mandatory duty, but it should be taken as a trust of the people, by the people, and for the people. And with this kind of a novelty of the jurisprudence which has been laid down by Justice Krishna Iyer in the case of Municipal Council Ratlam versus Vardichan, then we see that this judgment have a major repercussion in controlling in independent India and the contemporary India, the landmark cases which represented, and the gist and the essence of this judgment, the ratio and as well as the arbiter of this judgment have a ripple effect into what we can say. Number one is the uncontrolled garbage accumulation, heaps and tons of garbages which are accumulated in all urban sprawl, cities, and even the rural areas, and then their accumulation creates havoc to the public health and safety and their peace and tranquility. And then we see that this judgment have a direct impact on its control of the garbage accumulation, heaps and tons of garbage, the malodorous fume, the obnoxious fume, the insanitary conditions, and all conditions which seriously compromise the decency and dignity of the individual, which has been envisaged under Article 47 of the Indian Constitution. And it also talks about, it also comes very heavily about the poor town planning and the sanitary condition, that how sanitation in the town and the rural areas and in the entire cities can be controlled by the municipal council, and then any kind of a negligence on the part of the municipal administration cannot be accepted once the Supreme Court have been very rigorously followed its opinion that whether you have money, you have finances, you have fund, or whether you don't have the fund, or you are having a kind of financial starvation or financial crunch, it's not important. Once you are in a statutory authority under a statute, under a particular law, then it is incumbent on you to swing into action and do not compromise on the aspect of health, safety, sanitation, cleanness of the cities and towns. Otherwise, it will be a kind of a miserable failure of the very sanctity and legitimacy of any kind of a municipal council, and then it interpreted the public health and the safety to the utmost priority, and facets which is called non-negotiable facets of the human right taken as a whole. What we see that never before Section 268, Section 188 IPC, Section 290 of the IPC, and Section 133 CRPC, primarily Section 268 of the IPC and Section 133 CRPC, have witnessed such a kind of an interpretation right from the edifice of the Supreme Court and the rampart of the Supreme Court, as we have seen in the judgment of the Municipal Council versus Vardichan, in 1980, and while delineating a very salutary jurisprudence or a kind of a very effective jurisprudence to build around the law of public nuisance under Section 268 of IPC and Section 133 CRPC, is touched upon on the issue of Section 188 of the IPC and as well as Section 290 of the Indian Penal Code 1860, and it goes beyond that point and try to see that what Article 47 of the Indian Constitution talks about, that goal of the directive principles of a state policy. Vis-a-vis, it also invoked Article 39 of the directive principles of a state policy that has taken a very people-oriented jurisprudence, the common man's jurisprudence, common man's welfare and betterment, which has been envisaged under Article 39 and Article 47 of the Indian Constitution, that was invoked by Justice V.R. Krishna Iyer and Justice O. Chinnappa Reddy, and then taken as a whole, that it tries to say that right to clean and decent environment as a fundamental right and a human right, and that human right safeguards against all kind of the negligences and all kind of the failure, all kind of the indifference, all kind of the callous attitude of the municipal council vis-a-vis the magistracy which exists in every district headquarter to remove the filth and garbage and to make conditional order for the removal of public nuisance. Thus, the noted writer on environmental law, Armin Rosenkranz, has rightly said that this judgment has invigorated fresh stamina and vigor into the seemingly dull legislation. And the seemingly dull legislation, what Rosenkranz wanted to convey about was 268 and 133 CRPC. Never before that we have seen so much of the vital points under these two laws as it has been underlined in the judgment of the Municipal Council Ratlam versus Verdichand. So Armin Rosenkranz was of the view that it reinvigorated fresh stamina and new lease of life into the provisions of Section 268 of IPC, Section 188 of IPC, and Section 290 of the IPC vis-a-vis Section 133 CRPC. Taking Michael Anderson, who were writing on the private law of public nuisance and private defenses and the private remedy right from 1860 to 1980 was a kind of an article which Michael Anderson has offered to look at the very potentiality of the Municipal Council Ratlam versus Verdichand, and then it tries to see that how the Britishers in colonial India have made this law to serve their own civil rights and civility, but this law remained underutilized and happens to be a seemingly dull legislation, but how the Supreme Court of India through Justice V.R. Krishna Iyer and O. Chinnappa Reddy in Municipal Council Ratlam versus Verdichand in 90 tries to see the entire law of the public nuisance and entire law of the common law remedies of the public nuisance in independent India from the prism of the human right, from the lens of right to sanitation, and from a kind of a perspective that it is a non-negotiable facets of human right, is something very salubrious to understand and to note, and it has not brought to the fruition unless and until it was laid down by the Municipal Council Ratlam versus Verdichand by the Supreme Court. So, my dear learner and viewer, this case goes a long way in creating the relevance of the common law remedies of environment protection in general and the common law remedies in reference to the law of public nuisance in independent India to eradicate all kinds of pollution, all kinds of the environmental degradation, and to promote the sustainable future of the Indian people. With this, I thank and I wish you a happy learning.